Okay, well, thank you very much for joining us. Hello, and welcome to our webinar, Employee Handbooks, Common Mistakes Employers Should Avoid. Today, we're partnering with MPHR. All attendees are in listen-only mode. We'll have a Q&A session at the end of the presentation. The webinar today will be recorded and distributed via email. We'll also post it on sentinelgroup.com. If you'd like to ask a question, please add any questions in the Q&A chat at the bottom of the Zoom window. We'll try and stop briefly throughout the presentation and answer any questions during, if it's applicable to that particular slide. If not, as I mentioned, we'll make sure we have some time at the end. So I'm your host, Ben Healy. I work at Sentinel Group. I've been at Sentinel for over 13 years, and we're really a full-service employee benefits consulting firm. We take a holistic approach to helping people prepare for the future health, wealth, and retirement needs, whether that's retirement plans, group health benefits, reimbursement accounts, financial planning, whatever it is, we like to think that we've got you covered. Certainly excited to be here today, and we're excited to be partnering with Paul Carelis of MP. MP is a full-service human capital management services company offering a suite of different products and services, including HR, payroll, benefits administration, time and attendance, and compliance. Presenting today is Paul. I'm going to be here in a facilitation role. Paul has over a decade of experience in the HR consulting space, working with numerous businesses and industries. Paul leads a team of SHRM certified HR professionals in MP. Together, they assist clients with compliance, training, HR guidance, and support a full employee life cycle. Paul has also spearheaded MP's employee retention tax services. This initiative has helped save thousands of client claims, over $100 million in refundable advanced tax credits. Very excited to turn it over to Paul in just 1 minute, but of course, no presentation would be complete without a legal disclaimer. So this training is intended for educational and information purposes. While we do hope you take a lot away from today and learn a lot, we are not attorneys and the information should not be construed as legal advice. Information in the presentation is updated as of November of this year. So without further ado, Paul, please take us away.
Great. Thank you so much, Ben. Welcome, everybody. Good afternoon or good morning, depending on what time zone you're in. Really looking forward to covering this topic. It's a topic that's ever changing, whether it be at the federal level and the presidential administration or the Department of Labor or the National Labor Relations Board and its respective makeup, or states across the country as they change rules, laws, protected classes, and all of that. The employee handbook is really something that needs to be a living, breathing document and keeping up with the latest and greatest, whether it be changes in employment laws or sometimes more importantly, changes in how a law is interpreted. So oftentimes it doesn't require a new law or a new regulation to really prompt you to review your handbook policy. Sometimes it can be, some kind of landmark court case, whether that be at the state level or the federal level, but based on how the courts are interpreting things might cause you or require you to really take a look at your policies. And sometimes that means changing them. Sometimes that simply means changing some of the language, but this is one of the key employment documents and key pieces of your HR infrastructure that you really do want to make sure you're happy with, that it communicates about your business in many ways and really serves as a guide for your staff and your leaders. So in terms of what we will go over today in the next little bit, why do you need an employee handbook? What to include, and sometimes more importantly, what not to include in your handbook. We'll talk about some of the policies if you do have an existing handbook that you may want to review or perhaps change or update in the coming year. And then we'll close with the top 10 handbook mistakes to avoid, things that we've seen as we've reviewed handbooks or worked with businesses that had pre-existing handbooks and other studies of case law that have come back to hurt businesses in terms of handbook policy. So there are many reasons why a handbook is a good, if not necessary, component to your business and your compliance strategy. First, aside from all the check the boxes and having, this must-have policy or that, it is a great vehicle to really set the tone for your company's mission, your core values, and the culture. So it could be just as subtle as the way that the policies are phrased or worded. I mean, you don't want to get too casual with it, but you also want to make it so that it sounds that it's in the voice of your organization. Um, so again, it's a great opportunity to share the history of the company, how you've grown, what you stand for, what you look for in terms of your staff and your expectations. So speaking of that, it is a great way to communicate expectations. Much like a job description, it becomes a handy tool when it comes to coaching or counseling. Whenever you can reference something that's in writing, whether again it be a job description or a handbook, it's great to be able to point to that rather than having something that was assumed or that you figured people would understand. If it's in writing, it gives you a better leg to stand on there and reduces the opportunity for back and forth when it comes to difficult employee conversations. Also, a great way, and this is something Ben can obviously speak to as well as an expert in the benefits field. It's a great way to showcase the benefits that you offer to your employees. So sometimes you want to be cautious about how much detail and finite things, like you might not want to put the rates and things like that in the handbook, just because those are ever changing and one less thing to have to review on a constant basis. But definitely a great opportunity to showcase the things that you offer, whether it be unique types of leave or unique insurance benefits or disability or life, or work with companies sometimes that offer pet insurance and things like that. So whatever it may be, whatever your portfolio of benefits and perks that you offer to your employees, this is a great way to house it in one area and allow you to point to that, whether it be for recruiting purposes or retention purposes. Um, the most obvious is probably the compliance piece. So again, should you be in the unfortunate shoes of being someone who's being audited or contesting an employment claim, or finding yourself in a worst case scenario in a courtroom, or talking to a labor attorney, I'll tell you from experience through clients that having something in writing that points to what the expectation was, what the policy violation was, so on and so forth, or that the harassment policy had been communicated to the employees via the handbook, things like that, that comes in very, very handy when it comes to um, showing that you are compliant and following state or federal labor laws. Also a great tool for managers. So one important thing to note is that if you're new to the handbook game, or even if you're not, once you have a handbook that you're happy with, it's really, really important that you spend some time with your managers, supervisors, leadership team to make sure that they understand the book. Do some training with them. Make sure they understand the policies. Um, as you probably often have heard from HR, consistency is really important. So you want to make sure that the policies that are in here are going to be reasonable for you as a business to follow, that they're setting the tone, they're what you expect and are willing to enforce. And most importantly, you want to make sure that your managers and supervisors are familiar with these policies and that they're willing and able to enforce them as well. Because we've seen cases where they'll have certain language in there or certain rules in there that aren't actually being followed in practice, and that can sometimes jeopardize the legitimacy of the entire handbook if it's not found to be consistently followed or used. It's also a great resource for employees. So often now in businesses, everyone is really busy, especially on the administrative side and on the HR side. We're wearing a lot of hats. Anything that you can do to reduce the administrative burden on those teams is helpful. So by having a handbook that you're confident in and that does a really good job of explaining what your company offers and what the rules are, yeah, and if you have it in a platform or housed somewhere where employees have easy access to it, you can easily get them in the habit of checking that before maybe asking questions or going to someone else about something. So again, important that it's up to date and that it's accurate, but if it is, it can be a great resource for your employees and reduce the amount of times they're going to HR or their manager with questions. And then, as we said, obviously it helps defend against employee claims if you have something in writing, documented, and acknowledged by said employee. All right, so one real important thing and something that I've seen businesses stumble on is that you may be able to Google or talk to someone in your peer group or another business, maybe even in your industry, that you're friendly with and get a copy of a handbook that was created for someone else, or a generic template. I would definitely recommend against it, and if you do, exercise extreme caution, because it can get you into all kinds and all sorts of jams. One example I can think of is we started working with a business, and they came to us and started working with us because they had an issue with someone who was out on FMLA leave, and the leave had expired, and they needed to know what to do next. And in talking with them and going through the usual questions, when it came to asking about the number of employees, they had, say, 20 or 25. And so that didn't quite jive, because for someone to be subject to FMLA, you typically would have to have 50 or more employees. So, as we questioned, we realized that they had gotten their handbook from another nonprofit who was larger and was subject to FMLA, but because they had that in their handbook and were observing it, they were now subject to FMLA, even though they really didn't have to be, and wouldn't have had to be in the situation they were in. So that's just one of the many reasons why you really want to take a custom approach to your handbook and make sure it's made just for you. So some of the considerations that you have to go through to determine what your handbook is going to end up like. First, the number of employees. Again, that will dictate what policies you have to have or don't have to have, especially when it comes to state law. Those can vary greatly depending on the number of employees you have. Also, locations and states in which you operate. So this is really the crux of why the importance of handbooks has really exploded in the last couple of years. So um, if you were a brick and mortar business and did all of your operations in one state, let's say it was New Hampshire, as long as your handbook was compliant for federal law and New Hampshire law, you were good. But what happened over time, both because of technology and to a larger scale because of the pandemic, so many employers became open and willing to hire people remotely, and oftentimes those remote employees might be situated in other states. So in addition to expanding your business and having different business locations, one thing that's really important to recognize and realize is that if you have employees working in other states outside of where you're headquartered, or where you were headquartered when you made your last updates to your handbook, you're probably now subject to state laws that you weren't before. So we're doing a ton of work with businesses who have remote workers, sometimes just one or two, sometimes several in other states, because you are now a multi-state employer by definition, and you need to make sure your handbook is compliant for those states. Whether that be baked into your one general handbook, or if you have an addendum at the end for each state that you're now in separately, it is important to address those states in your handbook. You also want to be cognizant of your industry. So sometimes that can simply be a best practice and knowing who your audience is. But there are also, when we talk about where I'm sitting in Massachusetts, there are blue laws. And, some of those are dependent on industry. The rules for premium pay for retail workers is different for office workers and things like that. So it's important you factor in your industry to your handbook design. Also, government contractors. So, especially over the last decade or so, we've seen a ton of regulations specific to government contractors, whether that be affirmative action plans or mandatory minimum wages or mandatory sick pay, things like that. So, if you are a government contractor, there's likely unique policies that you'll need to have in your handbook. And if you're borrowing a handbook from someone who is a government contractor and you're not, there's also some things you can probably peel out of there. Another really important one is unionization. So we'll talk about in a moment the importance of employment at will, and having that kind of language in your handbook. If someone is under a collective bargaining agreement and is a union environment, that they are a contracted employee. They are not an employee at will. So if you do have a mix of union and non-union employees, you will want to have separate handbooks, one that is made in accordance with the collective bargaining agreement and follows those rules, and one that kind of follows a more standard set of the labor laws for non-union employees. Then in terms of your workforce, you want to make sure, depending on your stance on diversity and what you do in those areas, handbook's a great place to showcase that. Also, your employment categories, especially when it comes to things like benefits or perks, defining what those categories are. How many hours does an employee need to work to be considered full-time at your organization? Things like that. Again, we talked about telecommuters and the multi-state aspect there. Also, it's a great place to level set on your expectations for people working remotely and working from home, that they need to be free from distraction, that they're expected to be available the same as people in the office, or not, so on and so forth. Um, and then you want to make sure that you're reaching as many people as possible and that your policies are digestible by them. So, um, as much as you do sometimes have to have some legal jargon in there, and there's no doubt about that, you want to make sure that your policies, especially if you're put to audit or put to a court case, that it's reasonable for your employees to have understood the policies. Um, if you have people who struggle or there's a language barrier, depending on the population, if you have, say, a large Spanish speaking population as part of your workforce, you may want to consider having your handbook translated into that language. If it's just a few, then you can work with someone to hopefully communicate the policies to those individuals. But it's just something to take into consideration as you put together your handbook game plan.
Paul, one thing to consider from a handbook's standpoint about workforce demographics and telecommuters, obviously a lot of people went through a transition to working from home during the pandemic. Are some of the expectations around, working from home is not a replacement for childcare, as an example? Are those the kinds of expectations that you would put in telecommuters?
Yeah, definitely. So definitely the child care aspect, the availability aspect, expectations in terms of the workplace, free from noise, what the company is going to provide for equipment versus what the employee is expected to pay for. Are you giving them a desk and a chair, or pens and office supplies even? What are the expectations there? Because we've seen a lot of rub where people want to work from home, and then they want the company to supply them with every last thing, and the company had a different understanding. So whatever that looks like in terms of expectations are the types of things you want to address. But yeah, childcare is definitely an important one.
Great.
Great point. All right. So in terms of basic handbook do's and don'ts, you do want to put things in writing. Um, Increasingly as we study more and more case law, the bar for what an employee should assume or should have known if it isn't put in writing is very, very, very low. So the more that you can put into writing and point to policy will be helpful. This is especially true in unemployment cases. Unemployment claims are very difficult to win, even when you are terminating someone for cause. So the more that you can speak to a specific policy violation, that would increase your chances of being able to justify why you're appealing an unemployment claim. As we said before, you don't want to get too detailed. You don't want to paint yourself into a corner. So you do want to leave managerial discretion. That's why a lot of times you'll see that, if someone violates a policy, there'll be disciplinary action up to and including termination. So we generally avoid, unless it's a union and, it's mandated this way, we'll generally avoid going like a three strikes law or a three strikes rule, or, a points-based system. We like to give businesses a little bit more discretion to, on a case-by-case basis, determine what the severity of a violation is. Was it an honest mistake, or was it something malicious? You want to give yourself some flexibility there in terms of discipline. As we said, do your best to make sure you are applying your policies consistently, and again, most importantly, that your managers and supervisors are. Um, if you've if you've viewed any of our content before, especially on the topic of harassment, you'll know that managers and supervisors are considered agents of your business. So the things that they do and say, or perhaps don't do or don't say, are essentially what your company is doing. So you're on the line for their action, so you want to make sure that they're applying your rules and policies consistently. Do communicate this to everybody. Great if you have an intranet or employee self-service, or a place to make sure that they have 24/7 access to it. That's great. You do want to make sure you get an acknowledgement. So in the old days, that used to be signing the last page of the book and physically turning that in. In this day and age, some people still do that, but others will have it e-signature or electronically acknowledged through their their employee portal, that's perfectly fine. You just want to make sure you have record of receipt and acknowledgement. One important thing there is, by signing the handbook, sometimes you'll get someone who's reluctant. They might take issue with something. This is an acknowledgement that you've received it. You certainly want to open up a dialogue for any questions or disputes. But by signing on the handbook, one thing, if you do get that pushback, is this isn't saying you agree with it all. You're just acknowledging receipt and acknowledging that these are the policies in place. And again, as we said before, make it as easy to read as possible. You don't want it to be intimidating. That's going to take away from that benefit we talked about before about being a good employee resource and relieving the administrative burden. If people don't understand it, if it starts off really clunky, they'll put it down and not pick it back up. So do make it as approachable as possible in terms of language and structure.
And Paul, we did receive a question submission I think fits perfectly into this, make it easy to read. So the statement in question, our current handbook is very text-based. Are graphics and callouts a good idea to add?
Yeah. I mean, definitely as appropriate. It would obviously depend on the application of it. But yeah, I mean, especially if that speaks to your culture and the style and chemistry within your organization, then I wouldn't shy away from it.
Are there certain things there you would caution against?
Yeah, I mean, I think once you get rolling down that hill, sometimes it can be a little too easy to get. You want to avoid things like sarcasm and jokes too much. I mean, you can keep it somewhat light, but it does need to be serious, and it is ultimately legally binding. So it can be a little bit light and approachable and a little bit casual, but at the end of the day, um, things that are in there are going to be taken as fact. So you just want to avoid getting too jokey or too casual or too loosey goosey with it. So it can sometimes be a fine line. I understand that's maybe a lousy response to the question, but definitely visuals are fine. You just want to avoid getting too far away from the serious nature, especially when it comes to specific policies like things like harassment and things like that. You probably want to follow the suggested language from your respective state and their harassment agency, just to avoid any misconstruing of the information.
Right. Thanks.
Great question. So in terms of must-have, and this came up a lot during the Obama administration's National Labor Relations Board. They did a lot of work examining workplace handbooks and workplace policies just to ensure that they weren't chilling to employee rights. And that's continued through before them and after them too. But at-will language is something really important to have if you're a non-union environment in your handbook, because there are things you're setting the rules and you're setting the expectations, and the last thing you want to do is imply in any way that this handbook that's being distributed is any type of guarantee or contractual obligation to maintain employment for any type of permanency. So it's really important at the start you get into your at-will language that says, just like it is in any non-union labor environment, that the employer or the employee can end the employment relationship at any time for any reason. So the handbook is a guide. It is your policies. You want to state that you'll communicate any changes in writing to these policies, but you want to avoid anything that would suggest that if you follow all these rules, you're guaranteed a job here, regardless of how the winds may change. So just really important that you have some at-will language, definitely an at-will statement at the beginning. And then when there are certain policies that might sound a little serious or really get into the legal jargon or be kind of demanding of the employees, sometimes it's appropriate to sprinkle in here that nothing in this policy changes the at-will nature of employment. So again, this is a great opportunity as you launch into your handbook, as long as you're not forgetting that at-will statement we just talked about, a great opportunity to talk about the culture, really showcase the culture and how you phrase things and the names of your policies or what you call your employees even. So again, you want this to sound in your voice. So if you call your employees team members or associates, you don't want the handbook to be referring to everyone as employees. You want it to be in your language. Um, but again, if you have a mission statement, if you have core values, if you have long-term organizational goals, throw those in there. We don't have to get caught up on the rules so much that we're not making this feel like a document that's part of the canon of our business. You do want to have an employee relations policy, and you do want to have a gender neutral language as much as possible. So especially if you have an older book, there might be certain gender tags in there that speak to one group and not another. So just be mindful of that. This can be especially true when it comes to parental leave. So more and more states have ruled that maternity leave policies are not quite current or legal, that what's offered to the mother should also be, or the birthing parent should be offered to the father as well. So it really is a state by state basis and can vary depending on your locale, but parental leave is definitely something you want to take a look at and make sure it's compliant with the state you're operating in. So do make sure you have some of the heavy hitting compliance policies. Harassment, definitely. And if you're in multiple states, you probably want to have a different harassment policy for each state, just because, when we're talking about the Equal Employment Opportunity Commission at the federal level, we'll talk about it in a second. There are federally protected classes, but then each state has its own set of protected classes as well, which may differ or may have additional folks who are protected. So you want to make sure that your harassment policy speaks to all of those. And then many states also really want to have a state-specific harassment policy, because generally it will speak to the commission or the agency at the state level who employees can go to if they wish, if with a harassment complaint. So we always train folks to try to keep things in-house and go to management and go to HR when they have harassment concerns, but in most states they want the policy to include the state and or federal options as well. Drug-free workplace is also a great idea. It's something, if you have an old one, again, you want to reconsider and see what it has to say, especially when it comes to things like marijuana. If it's a state where it's been legalized, there have been certain rulings that dictate how marijuana needs to be treated at the state level. Obviously, it's still illegal federally, but some states have rules in terms of testing or other treatment of marijuana in the workplace. So you want to keep an eye on that. Also, in terms of what your testing policies are. So if you do random drug testing, you want to make sure that that's in that policy so that it's not a surprise. If you do it, post-accident, if there's reason to believe, or if you do reasonable suspicion drug testing, or if you do drug testing at hire, make sure whatever your testing policy is or what you want it to be, if you want to reserve the right to do a drug test if there's reasonable suspicion, make sure that's in that policy so that when that uncomfortable conversation comes around, you can say, as it says in our drug-free workplace policy, we reserve the right to test upon reasonable suspicion, and that again gives you a better leg to stand on and less pushback. Compensation, in terms of what your pay periods are, how often you pay, exempt, non-exempt, what the allowable deductions are for exempt employees, things like that you do want to include in there. And then safety. So definitely want to have your protocols. You want your employee handbook to be about policies and not about procedure. But some basic procedural things like who to go to if you are injured on the job, what the process is there, that's something you do want to include just to show you're making a good faith effort to have a workplace free of safety issues. Another one, and this one comes up often, and employers that don't have this in their handbook often kick themselves when they're trying to discipline, it would be attendance requirements. So if someone's going to be late or absent, who do they need to reach out to? What's the method? Are you okay with them texting or emailing? Are you expecting a phone call? Those are some of the things you might want to spell out in terms of your attendance policy. Another big one would be, within that attendance policy would be, when do you consider a job abandoned? So back in the old days, we used to say if it's 3 days, no call, no show, then we'll consider that you've abandoned your position. That's scaled back quite a bit. Again, people have cell phones, people have other ways of communicating, and there can always be an exception. Gee, if someone's in a coma, obviously they can't call into work, but we've seen people trim that down to 2 days or even one day. No call, no show is assumed that you've abandoned your position. So that comes up more often than you'd think. So you do want to have that in there, that when you consider a job abandoned, and then again, be as consistent as reasonable with it.
And in specific to that, Paul, you mentioned 2 days. I think I've heard, sort of the standard being three.
Yeah.
Are there concerns around that specific policy with going, too little, too many? Too
Yeah, I
many
mean,
maybe operationally, I guess.
yeah, too many operationally. At the very least, you want to have something in there that, again, there can be exceptions. If someone calls and said, hey, I lost my spouse and I was in such a whirlwind that I didn't even think about my job, and you want to be a compassionate employer in most cases, and you can always make an exception. I think, again, in this day and age, and depending on your industry, this comes up a lot when we work with restaurants and retailers and people who have a staff that may not be as professionally minded or as committed to the company, that you do have some teeth in there, so people don't think that if their vacation day doesn't get approved, they can just no show for a weekend and come back in and nothing has happened. That
Yeah.
this comes in a lot, again, when you're responding to unemployment claims, because um, having that in there and then backing it up with some sort of communication that, in accordance with our policy, you didn't call, you didn't show up for X number of days, that that communicates it as a voluntary termination, that they left the job, versus them being able to turn the tables and say that they were involuntarily terminated. So it's nuanced, but it can come in really handy. Standards of conduct and performance. So this is a really important one, and this is one that comes up quite often in practice. And it's impossible to list everything that you may want to include in there. We have samples available of what it may include. Some basic things in terms of no inappropriate relations with customers or clients, um, not gambling. You might have certain language parameters in terms of your standards of conduct. But at the end, whatever your list is, and as long or as short as it may be, you want to make sure to point out that this is not an all-inclusive list, and just a general idea and standard of what the expectations are. So standards of conduct definitely comes up often. Technology guidelines. So this is one you want to be mindful of when it comes to things like the National Labor Relations Act, and not chilling employees' rights to discuss their conditions of their employment, or potentially unionize and collectively gather and things like that. But you do want to be strict about certain things in terms of company confidential information, and whether or not that can be downloaded, or whether employees are allowed to use personal devices to access company information or company email. Also comes up with social media. So that's a policy that will often need tweaking to be in compliance with case law, but important for them to understand that, say, the harassment policies and the discrimination policies do apply to social media use. And also that, in terms of your stance on them representing the company via social media. Again, benefit information we talked about. It's a great opportunity to highlight that, what you have to offer. As we said, handling confidential or sensitive information. You don't want to be too vague with it, but company confidential information, you can give some examples: client lists, financial data, company secrets, as well as an employee complaint process. So if they have an issue, sometimes we like to have multiple options. So if you have a concern about your job, oftentimes your supervisor or manager is the best person to speak to. If that's not successful, or you don't feel comfortable, then go to this next level of management. Barring that, you can go to HR or the executive team, whatever, and then give them a pathway. So again, this is, aside from being a good policy in practice, this helps protect you in terms of showing a good faith effort of being an employer that had a way for, if an employee had a concern, that they had an opportunity and had a prescribed way for letting people know about it, so they can't make the claim that, hey, I was in this spot but I didn't know who to go to with it. Being able to have this policy in there counters that argument. So some things that you'll want to be especially mindful of and may require tweaking for the 2023 calendar year. First will be the equal employment opportunity statement that you have. Many states have enacted additional protected classes, whether that be gender identity, genetics. Many states are now adding hairstyles um, into the protected classes, and there's the Crown Act. So culturally significant hairstyles and things like that are considered a protected class in many states now. So you want to take a look at that and make sure you have an updated list of protected classes. Same and similar goes for workplace harassment. Want to make sure that you have your protected classes and methods of communicating or making a complaint are updated. Paid family and medical leave. So we'll go over this, I believe, in an upcoming slide, but more and more states are adding paid family medical leave programs. So if you have employees in those states, you want to make sure that you have the required policy that lays out what the plan does and how to go about enacting the plan if they have a qualifying event. Similarly, a lot of states continue to add paid sick leave programs, so you want to make sure that you have a compliant policy in place for workers in those states. Sometimes it depends on your employee count, whether that's paid sick leave. Sometimes for smaller employees, they just have to provide job protected leave, but it can be unpaid. Again, you just want to make sure you're compliant with your respective states there. Equal pay and wage discrimination. So this is probably one of the burgeoning topics when it comes to employment law state by state. So some states are now requiring job postings to have a pay range on them. Some are requiring job descriptions to include pay amounts. There's a lot more going on with pay transparency, equal pay, discrimination, not having a policy in there that prohibits employees from discussing pay with one another. Those are things you want to kind of run through your HR lens when it comes to your policies in your existing book. And then, as we said a couple slides ago, just what your rules and policies are around substance use and testing as well. So states are getting more on the ball with that and creating different hurdles there. So you just want to make sure that your policies are in line with the latest and the greatest at the state level. All right, so as we said, the Equal Employment Opportunity Commission handles discrimination claims at the federal level. And I believe this is their fiscal year 2021 data. So these are the number of complaints they received based on discrimination against each protected class at the federal level. So retaliation continues to be the #1 item. So it's really important as employers that if we get harassment claims and those come to our attention, that not only do we take those seriously, do an investigation, handle it as appropriate, but really, really important that you communicate to the affected employee that came forward, whether or not ultimately you find that there was harassment occurring. Assuming that the complaint was made in good faith and that they didn't make things up or frame someone, that's a different can of worms. But if they came forward with a complaint and it was in good faith, again, whether or not discrimination actually occurred, or it didn't quite rise to that level, that employee is protected from being retaliated against. So it's really important that you communicate that to the employee, communicate it to their managers and leaders, and also follow up and check in on the employee, because as you can see, just a ton of retaliation claims, and this is the #1 category each and every year that I've been in this space. Retaliation is the #1 complaint that makes it to the EEOC. So, you know, the tough thing is it's oftentimes not our star employees that are victims or that come forward with complaints of harassment, but you do need to be consistent with your treatment of them. You need to make sure that their accuser doesn't do anything adverse to their employment, that they're not treated differently, that all of a sudden there isn't a closer eye kept on their attendance than there is to other employees. Just something to be really mindful of. And one way to really effectively communicate that is to make sure that you're speaking to the handbook, and again, being consistent with your policies and your execution of those policies to avoid these retaliation claims. So these are the protected classes at the federal level. Again, you want to make sure you're familiar with those at state level as well. So just as an example, gender identity is one of the newer protected classes in many states. Not directly related to handbook policy, but just kind of an important adjacent item. Um, if you have employees in any of the states listed here, you do want to make sure that you're conducting annual harassment training. So California, Connecticut, Delaware, Illinois, Maine, New York, Washington, and DC. Um, Sometimes those hinge on the number of employees you have company-wide. Sometimes it hinges on the number of employees you have in that state. Sometimes it's regardless of that. If you have one employee in that state, you need to conduct harassment training. Some of the states, California, for instance, also require training for employees who manage employees in those states. So again, in this remote environment, you might have some employees in California managed by someone in Massachusetts. In most cases, that Massachusetts manager will also need to go through the required California manager's harassment training. And it's a long one too. I believe it's 2 hours. So do make sure you're compliant there. Some other states encourage harassment training, but don't yet legally require it. Those are Colorado, Massachusetts, Rhode Island, and Vermont.
And Paul, what's the largest classification of what drives the requirement? If we're a organization that's incorporated in Delaware, do we need to do it for all of our employees, or is it by
No,
whatever
generally it's usually
jurisdiction?
where employees are sitting. So whether that be in an office or at home, it'll generally be where they're performing the majority of their work. So sometimes that's tough in, say, a sales position where they're touching multiple states. It'd likely be where the predominant amount or the largest percentage of their work is being done.
And this harassment training would be something that would be done annually as a requirement?
Yeah, in most cases, it's an annual requirement. Um, and then it varies. So in each of these states, they have specific items that need to be included in the training. So you just want to make sure that, whichever the state is, that you're meeting the requirements in those states. So I know like Illinois, for instance, has certain things that they require to be covered in their harassment training. California's has content requirements as well as time. So I believe the employee one has to be at least an hour and a half, and the manager one has to be at least 2 hours. I might be off slightly on that, but just as an example.
Okay, and we did have a question come through too
Sure.
relating to harassment policies.
Yeah.
Is there a place to find the different state harassment policies that's organized nicely?
Yeah, I mean, certainly at MP we have resources available. If you reach out to us, we'd be happy to get you that. Other than that, it's a little bit tricky. I believe the EEOC, if you go to eeoc.gov, they have links to each state's department because it's a different name. So in Massachusetts, it's MCAD, the Massachusetts Commission Against Discrimination, that has their sample policy. In New Hampshire, I believe it's the New Hampshire Department of Human Rights. So the names of the departments of the state level can be different, but I believe if you go to eeoc.gov, they have links to the respective state agencies that would most likely have a sample policy.
Great, thank you.
All right, so as I spoke about a moment ago, more and more states are adding required family medical leave laws. So in years past, as I said in my example, that was from years ago, FMLA was only in play if you had 50 or more employees. That game is really changing. So in many of these states, any number of employees that you have, these employees are now eligible for a paid family medical leave program. So Colorado and Oregon are the newest. Those will start up in the new year. New Hampshire as well, but New Hampshire's is really different in that it's an optional program that employers can opt into. Most of these other programs in the other states are really a mandatory, obligatory participation where you have to be, remitting a payment and sometimes collecting a fee from the employees as well to participate in the program. The New Hampshire one is really just kind of a private disability program that certain employers have access to if they want to opt in. But in the other states, it is much more obligatory. So if you do business in any of these states listed here, you want to make sure that you're in compliance with the PFML laws there. Many of them have required employee notices. It's good or required to have the policy in your handbook. You also probably around this time of year have to do a separate issuing of a notice as well that talks about the rates for the new year. So these come into play both when an employee becomes injured or disabled themselves. Also comes into play when an employee has a child, either by birth or adoption. and in many cases also covers family members, and sometimes a different set of family members than the federal FMLA does. So some of these states, for instance, will cover, if an employee needs to take leave to care for a grandparent or an uncle or an aunt or a sibling, that sometimes the federal FMLA doesn't include as a covered family member. So if you're in these states, make sure you have PFML policies in your book and that you're also otherwise in compliance. All right. And then we've got, again, as we said, just an increasing number of states with sick leave laws. So again, sometimes these can be dependent on the number of employees you have in a state. So the states listed here are the current states that have paid sick leave laws. That's ever growing each and every year. And then you also will see on the right that certain cities and counties also have their own sick laws. And oftentimes you'll see that these are in states that already have a mandatory sick law. So you just, as always with any employment law, you need to do whatever is most generous for the employee. So if the city or county regulation provides more of a benefit than the state level one does, you want to follow that city or county sick law. So as we said, probably the hottest and newest topic when it comes to policy consideration has to do with equal pay, wage discrimination, and pay transparency. So more and more states are enacting laws that prohibit discrimination based on compensation when it comes to protected classes. Sometimes it's gender specific, sometimes it covers all the protected classes. Again, so you want to make sure that your policies are compliant with that they, if you have a stance on that or if you have values related to that they're spoken to in the handbook. Again, wage transparency is big. There are several states, and I believe now at the federal level as well, that prohibit you from prohibiting employees from discussing wages. So if you do have a outdated policy on that, you want to consider removing it. And then also more and more states are eliminating the ability for employers to inquire about salary history of employees from past positions. So if you are in one of those states, a lot of times it has to do with pre-employment, but make sure that you don't have anything contradictory to that in your handbook. So this is just a map, and we'll make sure everyone gets a copy of the slides where when it comes to marijuana, whether it's allowed medicinally, recreationally, or both, this can sometimes impact your ability when it comes to drug testing and making decisions, the actions you can take when it comes to marijuana specifically. So each state is ruled differently on this in terms of case law. So you really want to talk to an HR or legal professional if you do have a testing program in place to make sure that it's compliant with your given state. But as we all know, this is a ever-changing topic. Each year that we have a election and some ballot initiatives, this map is updated, and this year is no different. So just make sure that your drug substance-free workplace and drug testing policies are keeping up with the laws and the court cases. So by no means do you need to allow people to come to work under the influence, whether that be drugs, alcohol, what have you. Even prescription drugs, if they're inhibiting someone's ability to perform their job, then that's an issue that you don't need to allow in your workplace. Tricky part is with things like marijuana and marijuana testing, they don't necessarily test inebriation. It can be weeks or months prior. So you just want to make sure that your policies in your handbook are up to date with what the current legal and trends and stance are on that. All right, so let's go over our top 10 handbook issues to avoid. So the first of which is policies not matching practice. As I said, that can really come back to bite you. I remember a case that happened a few years back now where an employee was terminated because of some colorful language they used, and they were pointing to a policy in their handbook that spoke about language, and then they had proof. I don't remember how, whether it was company emails or employee testimony, but to show that no, employees spoke like that all the time, and they were just singling out this employee because they were complaining about the work conditions and not, even though there was a policy in there, it wasn't actually followed in practice. So that eliminated the validity of the employer's argument. Next, again, failing to train your managers and supervisors. They are agents of your company. What they're doing is what your company is doing. So um, if behaving badly, they can be a huge liability to your business, but if they're properly trained and they're familiar and being consistent with your policies, they can be a huge asset to your organization. You want to avoid overly restrictive social media policy. So you can definitely say that employees can't represent your business or speak on behalf of the company. Um, Depending on your industry, they may have to follow FTC regulations as well when it comes to trading and stocks and value of the business. Certainly, you want to mention that harassment policies apply to social media, but um, at the same time, employees need to be free to, especially on their own time, talk amongst each other. Um, what's known as Section 7 of the National Labor Relations Act allows employees to discuss the conditions of their employment. So you got to be really careful before you discipline someone if you can see that two employees are talking together over social media and talking about their job or their employer or their boss. As tough as that sounds, you need to tread very carefully there because especially with the current makeup of the National Labor Relations Board and what they're looking to enact and take on, we don't want to be chilling to employee Section 7 rights. Another big mistake is not revising a handbook regularly. So, if it's been since the 2000s or the 90s since you've really taken a look and revamped your handbook, you're almost certainly out of date with your policy. So make sure you're looking at it at least annually. Failing to include required policies. So more and more as states especially pass new laws, new programs, new regulations, a lot of times there will be an employee communication component that can oftentimes be satisfied by a handbook policy. So make sure if there is a state level requirement that you have it in your book. You want to avoid a one-size-fits-all approach. So again, don't paint yourself into a corner when it comes to your policies. Um, if you have different states at play, if you have a multitude of states, you might want to consider addendums. Make sure that, it's a lot to ask of your managers and supervisors to follow this thing. So make sure you're leaving some room for exceptions and uh, making space for your employees as they come. As we said before, avoid anything overly detailed in terms of your disciplinary procedures. Um, the worst thing you can do is say that every employee is going to get 3 strikes. If they do something really serious and where you really don't feel safe having them, you want to have the right to be able to terminate them for a severe offense. So again, don't get yourself into a jam there. Again, omitting the at-will statement and disclaimers. So sometimes that can come off as a little bit of legalese or something that doesn't maybe jive with the voice of the book, but employment at will is super, super important to have in there. A handbook and offer letter that doesn't state employment at will can very easily be interpreted as a contract of employment. So it is important to have at will language in your book. Again, avoid using a boilerplate handbook. It's not going to speak to what you're doing in real life, so make sure you give some time and thought and consideration to your policies. And 10, failing to distribute. So, you put in all that work, you've worked with your team, you've worked with legal counsel or an HR professional. Don't let all that blood, sweat, and tears go to waste. Um, the handbook is something you should be proud about. Having it in place is the first step, but if you can't make the argument or show proof that it's been distributed to the employees and they've acknowledged that receipt, that's not going to do you any good. You're going to have a weak argument. Yeah, these are our rules, but if you haven't communicated them to the employees, then again, they lose their merit. So hopefully this has been a useful conversation that's given you some perspective and some things to take back to your company and your HR teams when it comes to best practice and best policy with your handbooks. Ben, do we have any other questions to address?
Yep, we do. And in the
Great.
interest of time, we'll kind of go rapid fire here. So
Sure.
we had a question related to the no call, no show policy. Should you include anything about the employer and if they should make contact with the employee, what level of detail to provide there?
Yeah, I mean, generally we don't have that in the policy. It'll simply say something like, if an employee does not show up to work and does not notify in accordance with this policy for a period of 2 consecutive days, it is assumed that the employee has abandoned their position. I mean, certainly you want to leave yourself that wiggle room, but if it's an employee, especially a longtime employee or someone that you don't you don't want to just wander off and go MIA, then um, you want to give your managers and yourself that discretion to be able to reach out. But I probably wouldn't write that as part of
Right.
the
Yeah.
policy or procedure.
Okay. Is it considered essential to provide state policy for every state in which you have a remote employee? And this is sort of something we talked about before this call. So
Mhm.
not an office, but maybe a single person working from home seemed to indicate that their legal counsel said there's some leeway in this. With so many people having remote workers, what's the
Yeah.
stance?
I mean, it's tricky. It's tough, especially if you just have, say, one sales rep in one place. Um, The answer to that really depends on the state you're in. As a blanket statement, I'd probably say yes, even if it's just a very brief addendum, or a separate set of a couple policies that you send over to the employee separately, if it isn't part of your global handbook, let's say. Um, but more and more, we're seeing so many more states have required notices or required policies that it does warrant having at least an addendum, or again, just a separate little couple pager that's got the required policies in it.
Yeah.
So in most cases, yes.
Okay. Related to harassment training, I think this is a clarification from one of the points you had made. So if you're a California employer, but have employees in other states that do not require harassment training, does the employee have to go through harassment training?
Most likely not. Yeah, when it comes to employment law in general, in most cases, the set of rules you need to worry about is where the employee is performing their work. So, um, in most cases, it's really pertains to where the employee is working.
Okay. Two other quick ones. If you have employees who live in DC and the business is in Maryland, you allow remote workers. Are you required to follow DC paid family medical leave and other DC laws?
Yeah, I mean, if the employee can make the argument that they're, again, for the majority of their time performing their work in District of Columbia, and then yeah, they're performing their work in the District of Columbia. Again, it might not be something where they're deriving, something that's going to require a corporate tax return there. They're not deriving revenue from there, but if they're performing work in that locale, then in most cases, yes, you're subject to the rules there.
Okay, thank you. And last but not least, in terms of the receipt of the handbook, do we have to have all employees show receipt of handbook if we post it on an internal portal for them to see at all times?
I would say yes.
And that's that
Again,
acknowledgement that you
eh,
would be looking for.
yeah, yeah, it doesn't have to be anything too major, but you want to be able to show proof that this employee received and acknowledge receiving. Um, as we've seen in cases and appeals and arguments, can come up with all kinds of excuses of why they didn't know about it, or didn't one excuse after the other. You want to eliminate any of those potential excuses. I'm sure your labor attorney would appreciate it if you get put in that position, that you at the very least have acknowledgement of receipt of the policies.
Excellent. Thank you.
Of course.
So I think we're right at the top of the hour. So what we'll
Perfect.
do is we'll wrap here. I know there's some questions about standard of conducts and maybe some examples. So Paul, maybe things when we host the presentation and the slides, we can include some links in that same spot
Definitely.
to some sample policies and just continue the collaboration that way.
That sounds great.
So thank you very much, Paul, for joining us. I think it's been a very informative session, and thank you all for attending. We at Sentinel certainly look forward to continuing new great content conversations like this in the new year, and we've already started planning out some of those sessions. Any upcoming event will be posted under the webinar section of sentinelgroup.com. Otherwise, thank you very much for your attention. Hope everybody has a happy holiday season.
Thank you.
Take care.